Good morning, everyone. Thank you for joining us today. We've got a few people still making their way in from the waiting room, but we're going to go ahead and get started as we usually do with our Zoom housekeeping reminders and instructions. The first thing that I will ask is that everybody remember to stay muted today unless you need to unmute yourself to ask a question. Just keeps background noise to a minimum and makes it easy for everybody to hear. Like I said, if you want to unmute yourself to ask a question, you're welcome to do that. The other way to ask a question is to put your question into the chat. I'm going to go ahead and pop a message into the chat right now. So that might make, might make a flash on your device, depending on what kind of device that you're on. But the chat is the best way to ask questions or to ask us to clarify something that we've said today. And you can also see in the message that I just posted in there that if you put a question here and we don't get to it today, Chelsea does try to keep track of them throughout the Q&A, but to be on the safe side, if you could email it to info@condolaw.net by 4 p.m. on Monday, that would be great. That gives us a day to research our answers to the questions and be prepared to talk about these issues every Wednesday morning. The chat message that I put in there also has the link to our YouTube channel, which is where we post all of these videos after the Q&A is over. Most of the time we get the video posted within like 24 or 48 hours. Last week's I just put up this morning. So forgive me if I'm not always super timely, but we do have a very long history of those recordings available on our YouTube channel, which is also searchable by search word or search term. So if you go to our YouTube channel and not in the YouTube search bar, but the channel specific search bar, if you put in some search terms, you might be able to find previous videos where we mentioned in the notes that we talked about certain subjects. Obviously, if you put in really common search terms like assessments or condo, you're probably going to get too many videos for the search to be useful to you, but other terms might give you the results that you're looking for. Just as we remind you every week, I'm also going to tell you again right now that we're not here to give legal advice. We're just here to talk about general legal information. So often we have to email people back when they send in the questions and say this is too specific for us to answer in the Zoom Q&A because you're asking for legal advice. If you find yourself sending us excerpts of your governing documents or telling us really specifically what your documents say about something, or including a lot of really detailed facts about a situation, you're probably asking for legal advice, which is not something that we can do in this forum. Whenever possible, we try to at least touch on the subject generally if we think that it's broadly applicable and helpful to people. But a lot of times we do say either here in the Q&A or in an email back to you, that's too specific. You really need to submit this question to your association attorney. And so I'm going to go on my periodic rant about association attorneys, which is if you are in a community or you work with a community that does not yet have a relationship with a community association attorney, you should correct that oversight now when it's not urgent, when you're not dealing with an emergency, when you're not being served with a lawsuit and given 20 days to respond. When you have time to explore all of the different law firms out there that do what we do and figure out which one might be a good fit to help with your community's needs in the future. I think that establishing that attorney-client relationship before you need it is extremely important and helpful, because what that means is that when you do get served with that lawsuit or an owner demands something and says the law means you have to do X, Y, Z, or whatever the thing is that you're dealing with, you have an established relationship with an attorney that you can call up or shoot a quick email and say, hey, this thing happened, what do we do? And they've got all your governing documents. They know what statute your community is governed by and can help you much more quickly than if you have to start the attorney search in that moment. So stepping down off my soapbox, related to the fact that we don't give legal advice, if somebody sends you one of these Q&A videos and says you have to do a thing or you can't do something because of something we've said here, you can ignore that, right? Any particular situation that you're dealing with, the only place you can get actual legal advice is by asking your association attorney. I am also going to put another link into the chat right now and remind you about the Washington State Community Associations Institute Legislative Action Committee's Monday Morning Minute. That's a mouthful. The link is in the chat. And what the Monday morning minute is that each legislative session you have to sign up for this. They don't keep the signups from one year to the next. And every Monday morning, our Legislative Action Committee chair has drafted an email that is sent out to the people that are on this list, updating you on something relevant to community associations that's happening in the legislative session at this moment in time. So you'll see information about all of the bills that we're tracking in our Legislative Action Committee, including the WUCIOA trailer bill, bills about lot splitting, bills about, I mean, there's probably 18 or 20, I think, bills that we have been following really closely in the LAC. Some of the emails will also include a call to action where we're asking you to contact your legislators to either voice your support or your opposition to a bill. We give information as to why we think the correct position is support or oppose. And there are links in those call to action emails that make it really easy for you to contact your legislators and support the position that WSCAI is asking you to support. And a lot of the requests for information that we get in this Q&A about things that are happening in the legislative session are easily answered if you subscribe to the Monday Morning Minute. So we've been telling you guys about this for weeks, and we probably will keep doing it until the legislative session is over, but that's something I would love it if everybody signed up for. And finally, our last generic or general update is that according to FinCEN, the new deadline to file an initial updated or corrected BOIR, Beneficial Owner Information Report, is now March 21 of 2025. So we have just under a month now before that new deadline. Now, just like we've been saying all along, there could be an injunction that stops enforcement of the requirement between now and then, but I would not bank on that. And we've been telling our clients for a really long time, and you've heard us say here that even when there is an injunction delaying implementation of this requirement, we think it's a good idea just to go ahead and comply, get it over with. There's a link in the chat to the FinCEN website for you to look into more information about that. So I think that I have covered all the housekeeping. And so without further ado, I'm going to give it to Lisa to take us away with our first question.
Sounds good. Good morning, everyone. First question. We have a unit owner who frequently requests HOA documents, financials, and other records, often framing his requests with legal language about the board's responsibilities. Over the years, we have responded to his inquiries. However, at this point, we're reaching a threshold where we are unsure if we're obligated to continue responding. Could you clarify what the Washington State RCW requires regarding the board's obligation to provide information to unit owners? Specifically, are there any limits on the frequency or scope of requests that the board must accommodate? The short answer to this question, or to these questions, is no. There are no limits on how many times an owner can ask for information. There are, however, limits on some of the information that you are required to provide. We've talked about these fairly extensively in prior Q&As, things like other owners' files, so information about another owner's unit, and then other information that may be required to be redacted. So if you're curious about really specific information on that, definitely do what Valerie was suggesting on the YouTube channel and search records. I think we have had lots of conversations about what things need to be redacted and how owners can't request other unit owners' files. But you might be able to reduce the frequency or the request by making these items accessible to owners. A lot of communities are starting to, with the help of management companies or sometimes on their own, having a portal that owners have specific access to. So you're an owner, you've registered, you are able to access the information, a lot of this stuff that it sounds like this particular owner is requesting. You'd want to make sure that things like account numbers were probably not accessible even by owners on that website, but we were talking earlier, Ken pointed out that some banks even redact account numbers on your statements. So just take a look at that if you're going to be posting things like that on an owner portal. You can also, we've talked about this before, draft some or enact some kind of a communications policy that sort of identifies to owners how they can go about requesting things, how frequently they'll respond. Maybe there's a timeline that you can put into place, or we respond to these requests on the 30th of the month or whatever it is that the owner, you're not doing it every time they drop something into your lap. But do keep in mind, depending on what kind of community you are, there may be timelines. For example, Kiowa does have specific dates. You know, if you make a request during, I think it's 10, if you upon 10 days notice, unless it's a really egregious request, you do have to then provide those information within that 10 days. You may have an extension up to 21 days in certain situations, but definitely keep that in mind. That's probably the guideline that a court would look at, even if you're not a WUCIOA community. So keep those things in mind. If someone's making a request every 10 days, you may have to comply every 10 days. But I think a communications policy could really help an association like this set up expectations. Certainly a portal could help. And know that if what they're asking for is something like the list of other owners, every owner in a community is entitled to that information once per year. So I think if someone's saying, every month is saying, send me another list of who owns a unit in this community, I think that's something you could probably reasonably restrict or limit the number of times you have to respond to that, because the statute just requires an annual compliance with that. Trying to think if there's anything else. An owner can ask for the documents electronically. Again, a portal would help with that kind of a thing, or they could request to see them in person. You can put restrictions on time, times and dates and hours when things can be viewed in person. So keep that in mind. They need to be reasonable requests. And if there is a cost for you of compiling that information, that may be appropriate to charge back to that owner. If it's an hourly fee of some staff person who's having to go in and dig out the documents and make copies of them and provide them to the owner, that may reasonably be something you can charge for. And you may want to talk to your counsel about that if you have questions about what's reasonable and how to make those charges to an owner and how to tell the owner that you're going to be charging them. Valerie, did I miss anything there?
No, I just would clarify a couple of things. If you do
Sure.
determine that you have the authority to charge an owner for a records request, you should tell them what the charges are going to be ahead of time and get their agreement to the charges, rather than providing them with the requested records and then slapping them with a bill after the fact. That's just, it's courtesy. It also might make them reconsider the volume of their records request if they understand that it's going to cost them money. The other thing I do want to clarify is that an association does not have to magically produce records that it does not possess. And you don't have to synthesize records in a specific format or order just because an owner demands them in that format or order. So to the extent that you have records electronically and they're easy enough to just email back to an owner when they ask you for them, provided you're complying with the statutory requirements to redact protected information, things like that, then sure, just go ahead and email them back to the owner. But if the owner is asking for, a certain compilation of documents, or for documents that are older and that they're in banker's boxes in the cabana storage room or whatever, you are not obligated to synthesize those into a format in which they do not currently exist. And in that scenario, it goes back to what Lisa was saying, which is that you tell them a reasonable time during business hours when they can come to the location where the records are kept and review them in the way in which they are kept, as they exist now. You don't have to turn them into a different format for the owner's convenience. So I'm going to go ahead and move on to question number 2 now. And it is about WUCIOA. So the question reads as follows. We are familiar with the portions of the original WUCIOA that impacted older HOAs. With WUCIOA for all, it is our understanding that additional sections of WUCIOA became immediately applicable to us, and that some amendments were made to WUCIOA. We also have the impression that there will likely be lots of additional amendments to WUCIOA before 2028. Is there a way to get the current amended version of WUCIOA? Is there a good way to get a complete list of what portions of WUCIOA apply to us now if we have not yet opted in? And are there likely going to be additional amendments to WUCIOA prior to January 1, 2028, such that we should put off having our governing documents updated until late 2027? So the first question is there a way to get the current amended version of WUCIOA? And Lisa, you beat me to it. There's a link in the chat. And the answer is you can access the full statute as it currently exists online. And WUCIOA is chapter RCW 64.90. And so if you just Google that, RCW 64.90, the first result will be the legislative website. And you can look at the entirety of the statute. You can also look at it broken down by subsection. And the subsections are all titled appropriately. So you can do a Control F in your browser if you're on a PC and search for a specific term if there's something specific that you want to learn about. So the second part of the question is there a good way to get a complete list of what portions of WUCIOA apply to us now if we have not yet opted in? And the short answer to this question is yes, because RCW 6490-365 is a list of all of the WUCIOA sections that apply to pre-existing communities. But I'll give you the cheat sheet or the Cliff Notes version. The only substantive sections of WUCIOA that currently apply to pre-existing communities are the budget ratification section, the reserve study section, and the section that speaks to how communities can adopt WUCIOA as their governing statute with lower voting requirements than a normal declaration amendment would require. So if you want those specific sections, I don't know, Lisa, if you want to type these in for me. The budget ratification section is 6490-525. The reserve study section is 6490-545. And by reference, that one also ends up including 550, just so you guys know. And the section that talks about how to adopt WUCIOA as your governing statute is 6490-370. So those are the sections that apply to everybody right now. However, newsflash, and this is not the first or the last time that we'll talk about this today. We've talked about this before as well. The current WUCIOA trailer bill, which is likely to be adopted this legislative session, makes modifications to a lot of different sections of WUCIOA as it currently exists and applies to WUCIOA communities. And also would make the meetings section of WUCIOA applicable to all communities effective January 1 of 2026. So most of this bill for non-WUCIOA communities, you can ignore for now, just understanding that it's going to modify WUCIOA as it exists, and that eventually in 2028, WUCIOA will apply to everybody. But also one section of this bill modifies the meetings section of WUCIOA and makes that section applicable to all communities effective January 1 of 2026. So that's one part of WUCIOA, or one additional part of WUCIOA that's going to then apply to everyone early. If this bill passes in its current form, I think that's the likely outcome here. So as to the question about like, when should you modify your governing documents with the, advent in 2028 of WUCIOA for all, but there might be changes between now and then. And does that mean that we shouldn't amend them now? Here's what I think. I think you can amend your documents now, and any changes that might be made to WUCIOA between now and 2028 are unlikely to be significant enough to make you regret doing a restatement. And I also think the legislature is probably going to be tinkering with WUCIOA for a long time. So there's a sort of an underlying assumption to this question, which is that once we get to January 1st, 2028, WUCIOA will be set in stone and there won't be any more changes. I'm not suggesting that the person who asked this question thinks that, but don't we wish things would be that easy and that predictable? I think what's going to happen is that in particular, going forward from January 1st, 2028, we're going to start to see the practical impact of the fact that the other statutes are gone away, and that WUCIOA is the last statute standing. And the legislature might have to do some tinkering even past that date as we learn about the ramifications of WUCIOA for all once it's enacted. So I think that any changes that are made between now and January 1, 2028 are likely not going to be so massive that you're going to think, oh man, we need to do a whole nother restatement in 2028 if you do one now in 2025, right? Plus, the statute as it exists when it is applicable to you will override any inconsistencies in your governing documents. So let's say, for example, you do a restatement this year, and then 2 years from now, there's an amendment that changes notice provisions or something. the statute, as it governs your community, when that notice section is amended in the future in this hypothetical, will override whatever your documents say, whether it's a document that you never restated, a document you restated in 2025, whatever, right? And you can always decide then at a future date, whether it's in 2028 or 2030 or whatever. Gosh, it feels like, I feel like we're talking about like the Jetsons or something when I say years like 2030. Anyways, you can decide then whether an amendment is something that your community would benefit from if the conflict between the statute and your documents as they exist at that time is confusing enough to make an amendment make sense. Also, communities can choose not to amend their governing documents at all. I think there is also, not in this question, but in a lot of the conversations that are happening around WUCIOA for All, there is an assumption that you have to restate your governing documents. Otherwise, something bad's going to happen when WUCIOA for All hits. And I think certainly there is the potential for confusion and annoyance when your documents are inconsistent with the statute. Because what will happen if you don't amend or restate your documents is that on January 1, 2028, the statute will now apply to you, and it will essentially invalidate anything inconsistent with the statute that's in your documents. But that's not going to magically erase those sections of your documents. They'll still exist. And so, you might have owners coming to you saying, why are you doing this thing when our documents say that thing? And then you're going to have to explain to them, look, the statute overrides the documents, blah, 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 whatever. You're going to have to comply with the statute, even if you don't amend your documents. And so if you choose not to amend or to delay an amendment or restatement, one thing we would recommend you consider doing is having your attorney draft you a memo telling you what provisions of the statute are overriding which sections of your documents, and telling you what can I do, what must I do, what can I not do now that WUCIOA for All is controlling over what's in my governing documents. And you can even ask your attorney to make that memo in a format that they understand will be disclosed to and shared with the ownership as a whole, so that when an owner comes to you and says, why are you doing this thing when the documents say that thing, you can be like, here's a memo that explains why. And that memo should be a lot cheaper than a full restatement of your governing documents. And so that might be a really reasonable alternative for communities that don't want to do a full restatement either now or in 2028. So going back to the questions, which were basically, I think some of like the gist of this question is like, how the heck do we track all this stuff? How do we figure out which sections apply to us? How do we know when we should amend our governing documents? And I'm going to go back to what I said earlier today, which is one way that you can stay informed of these potential changes is to subscribe to the Monday Morning Minute updates from the Legislative Action Committee through WSCAI. I wish there was a singular website out there that I could point you to that would be like, this is how WUCIOA started, and these are all the changes since then. And for every type of community, this is what exactly all these changes mean and will mean forever. But there isn't such a website out there. And honestly, even if there was, I don't know that I would trust it without having to parse through it all myself to make sure that it was fully accurate for every client. And then the last reminder I'll leave you all with is something I already said once, which is there's going to be modifications to WUCIOA long into the future. It's not just what happens between now and 2028. The legislature has a really strong interest in everything related to housing right now and has done for the last couple of years. I don't see that changing in the near future. And I also think once WUCIOA for All becomes enforceable and replaces all of the pre-existing statutes, we're going to learn about what hiccups are created by that process. And the legislature will probably do some tinkering to address any issues that might be created by that. So I think this is a exhaustive answer to the question. If you have requests for clarification, you pop them into the chat. Lisa, did you have anything you wanted to add before I move on to the next question?
I would just add quickly that if you are concerned about your specific documents, your attorney may be able to help you by creating some kind of a chart or a spreadsheet that says, this is your section of your declaration and this is what WUCIOA says about that, or this is what WUCIOA does. So if you really want to know what is going on with your situation, you may be able to have your counsel help you figure it out. And then we do that.
Yeah. All right, next question. I am interested in knowing how much work a condo board can do in private instead of in the open. I understand legal and HR issues needing to be done in private, but can a board meet for hours each month without letting the community know about it? So the short answer to this question, and the reason I'm taking two questions in a row is because it relates back to the WUCIOA for all thing that we were just talking about, is we always advocate open meetings, and that is going to be a requirement for everyone once WUCIOA for all is enacted. And I want to remind you all that the meetings section, if the bill that's currently under consideration by the legislature passes, is going to apply to everybody in January of 2026. It's not going to wait for 2028. So right now, the answer to this question for condo associations that don't have an open meeting requirement in their documents is different than it is for HOAs and WUCIOA communities, but it's not going to be different for very long. And so our answer to this question has been that we always advocate open meetings. We have advocated for open meetings for years, long before even WUCIOA was enacted as a statute. And what I would say is that even if you're a community that does not have an open meetings requirement right now, you should start practicing and behaving like you do, because you're going too soon, right? Because everyone is going too soon. So currently, though, only associations governed by the HOA Act, which is 6438, and by WUCIOA 6490, have an open meeting requirement. If you look at the WUCIOA meetings section, which again is going to be applicable to everybody here pretty soon, there is a really short list of the types of topics that are appropriate to discuss in executive session. And those things, you know, they include like consulting with your attorney about legal matters, or, you know, ongoing litigation or mediation, like current legal disputes, labor or personnel matters, contracts or leases or other things like that that are currently under negotiation, and in particular things that are like in an open bidding process, a competitive bidding process. Anything else that is essentially legally protected and private information. So if, for example, you have a homeowner who has come to you as a board to notify you that they are in a statutory program that protects their address, and they're asking for their address not to be published in the list of the owners within the community, that's a topic that would very appropriately be discussed in executive session, because it's a statutory private protected topic. Anything else should be discussed in open board meetings. And one of the things that I get the most often from people is, what about delinquencies? We don't want to be talking about people's private financial information in open meetings. And my answer to that is, the list in WUCIOA does not include delinquencies, and there are ways of talking about delinquencies that do not disclose people's private information. So if you work with a management company, it is highly likely that their software assigns an account number to each delinquent, or to each unit owner account. And so you can refer to each delinquency by the account number rather than by using the unit owner's name or unit number. If you are in a large enough community, you could also even use things like street addresses, which true, somebody could take the time to look that up and figure out who the person is. But, you know, in a larger community, the chances of that being, that's not as easy to do, especially for a layperson who doesn't know how to do this particular kind of research. Back to the actual question, which is, how much can boards do in private? And, you know, right now, if you're a condo association without an open meeting requirement, you can do a lot in private. But just because you can doesn't mean you should. You can thank my mom for that gem. And again, we have long been advocates of open meetings. We think transparency with your ownership is really important and goes a long way towards dispelling the sort of persistent myth that exists in many associations that the board is doing like, you know, shady dealings behind closed doors, when we understand that most boards are absolutely doing their very best with the information that's available to them to govern their communities fairly and in the best interest of the association. If you're a community that has an open meeting requirement, then your board should be doing very little to no business behind closed doors. And again, January 1, 2026, you're very likely all going to be subject to the WUCIOA meetings provisions, which will mean that everybody, regardless of community type, is going to have open board meeting requirements. That means you're going to have to allow owners not just to attend, but to speak at those board meetings with limited, there's limitations on that. It's not an unlimited right to speak, but they do get to address the board. You have to provide the agenda ahead of time, unless you publish an annual board meeting schedule in advance. And in that case, we would suggest you at least provide like a general agenda so that people know usually what the order of business is at least. And so even if you're a community that doesn't have an open meeting requirement now, you're going to soon, and you should start practicing. I will also offer that WUCIOA very specifically addresses things like you can't have a potluck and talk about board business to avoid calling it a board meeting, to avoid making it an open board meeting, right? So it's one thing if there's an actual potluck or a neighborhood party or whatever, and nobody's actually doing this for the purpose of concealing the fact that you're having a board meeting. If it's actually a social gathering, that's fine. But don't try to hide a board meeting behind a social gathering, because the statute very specifically recognizes and prohibits that way of avoiding open meetings. And the last thing that I'll say is we get a lot of questions like this, a lot. Like anybody who's been here often has heard us talk about this subject many times. And sometimes it's a little hard to tell whether the question is coming from a board member who's trying to get around the transparency requirements, or from a concerned homeowner who's in a community where they're not sure if the board is complying and being open and transparent with how they're doing business in their community. And honestly, the source of the question really doesn't matter. I think the answer is the same regardless, which is boards should be doing as much business as possible in board meetings, open whenever possible. And pretty soon you're not going to have a choice, even if you don't currently have to do open board meetings. So I'm going to shut up now. Lisa, if you have anything to add to that, feel free. Otherwise, you can move on.
I was just going to do two quick clarifications. One is that an executive session is not a standalone meeting. It should be basically a breakout session from a regular meeting. And two, no decisions should be made in that executive session.
Right.
And Valerie and I come across this a lot because we do a lot of collections work, and the statute is very specific that the board needs to make, needs to make a decision and move for a foreclosure if that is what happens. So you discussing it in your executive session and passing a motion is not appropriate. Unfortunately, we need that discussion. You can have the discussion in executive session, and then you need to come back into the regular meeting and have the discussion, and that, or have the motion. And that goes to Valerie's point about potentially using an account number or something if you're very concerned about privacy or privileged, what you consider privileged information.
Yeah. There is a follow-up question in the chat on this subject, so I'll address that really quickly. If the HOA board meets every month, but the CC&Rs only require them to meet twice a year, does that mean they are only legally required to open the meetings to homeowners for those two mandated meetings in the governing documents? And the answer to that is categorically no. If you're holding a board meeting and you are subject to an open board meeting requirement, every board meeting needs to be open. And what open means is you have to have given notice to the owners in compliance with the statutes. And there is case law around the country that has found that failing to give notice to the owners is a violation of an open meeting requirement. So it doesn't matter if your documents only require 2, but you're actually doing 12. You are required to give owners notice and allow them to attend as many board meetings as you hold, even if you have them twice a month. So take it away, Lisa.
All right, next question. If a board has borrowed from reserves, and one of the ways they are considering repaying that loan from the reserves is to increase the monthly dues for next year's budget instead of a special assessment, would this satisfy the state statute of repaying the reserves? And the short answer to this question is yes, as long as you're complying with the statute. As long as the borrowing of the funds and the repayment plan are noticed to owners as required in the statute, that is probably a very appropriate and sufficient means of repaying. Keep in mind a couple of things from the statute. You need to pay off that debt within 2 years, unless it becomes a burden or is a burden to the owners. So if increasing assessments over the next 2 years to pay off, I don't know how much the loan would be from reserves, would be burdensome on the owners, that may be something to take into consideration about whether or not that is an appropriate way of repaying that debt. You can look for reference, the WUCIOA section that discusses this is 649540, says the board must provide to unit owners along with the annual budget a notice of the withdrawal, a statement of the delinquency in the reserve funding on a per unit basis, and then also propose the repayment plan. So make sure you're just being very compliant with the statute, but that is, especially for a small loan from reserves, a very appropriate or possible way of doing a repayment for a loan from the reserves. Anything to add to that, Valerie?
Nothing to add, but there's a follow-up question in the chat, which is what is considered a burden? And I think there is no statutory definition of that. I think that is up to the board's discretion to determine what is an unreasonable burden. And what I would say is that I would want my client in making that decision to make sure it was very careful to satisfy the board's duty of care when making the decision. So that would mean they have to engage in an adequate inquiry as to what the impact would be on the ownership of repaying within the 2-year statutory requirement. And they'd need to be able to demonstrate that they actually looked into this and what factors they relied on in making a decision that it was unreasonable burden. Just saying it feels like a burden is probably not good enough. Did you have anything different to add to that?
No, I was just thinking when I was answering the question about special assessments, I'm not sure a special assessment or a regular assessment. I mean, they're both being charged to the owner. So whether one's more burdensome than another, I'm not sure that's I'm not sure that there's a distinction without a difference there. So, an assessment is an assessment against the owner. So you do have to look at the whole package.
Yes, absolutely. All right, next question. If a community is working on a reclad project and the board has weekly meetings with the contractor, would this be considered a board meeting and should it be open to the owners to attend? And I think the short answer to this question is just that it depends on the specifics of the meetings. Are there any board decisions being made? Don't rely on my answer to decide how to handle this in any specific community. Go ask the association attorney for the association in question what they think about it. But if the board has already made decisions to enter into the contract at appropriately noticed board meetings, whether they're open or not, depending on the requirement for this community, then weekly progress meetings might not require any board decisions. And so they might not be considered board meetings, but on the other hand, why not have them be open to the owners? Most of these types of meetings are going to be taking place during business hours. Most of your owners work, and the vast majority of them are not going to just show up randomly at these weekly progress report meetings with the contractor. But if some of them want to come, I don't see the harm in allowing them to do that. And again, if the idea behind all of this, I mean, the legislative intent behind all of the changes to our meetings provisions, eventually requiring open meetings for everybody, is this idea that transparency with the ownership should be required and is a benefit to most community associations. And I think that we absolutely agree that that is generally a benefit. So, if the full board is attending the meetings, if there's the potential for any decisions to be made at any of these meetings, then I think in an abundance of caution, notice them out to the owners. Set them at the same day and time every week. Let's say the progress meeting is going to be every Friday morning at 10 o'clock, and you're going to meet at the cabana or, whatever the location is. And then send out your meeting notice to the owners that says, from now until this project is over, or until we tell you otherwise, there is going to be a weekly progress meeting between the board and the contractor at the cabana or at building B or whatever. You're welcome to attend. Then you have acted in an abundance of caution. And if it turns out that you don't have a meeting in a particular week, then you can just notify the owners that the meeting is canceled, or put a sign up at the location where the meeting is to say, hey, no meeting this week, whatever. And then when the meetings are no longer occurring because the project has passed a certain point, then you can notify the owners that the meeting is being canceled. I would say, what's the harm in inviting them to attend? That would be my question. Lisa, do you have anything to add on that one?
Nope. Okay. I'll go to the next, unless you want to, was there one from the chat you want to follow up with, or no? Okay.
No, I don't think any of these are related.
Okay. Next question. The HOA bylaws in a 6438 community require the reserve account to be held in a commercial bank, savings bank, or savings and loan. Unfortunately, these options pay very low interest rates, and the board would like to move the reserve account to a credit union or a brokerage account where higher interest rates are available on insured accounts. Is a bylaw amendment required to move the reserve funds to these options? I'll start out by saying this is a pretty specific question, and we don't have your governing document, so I don't know exactly what your bylaws or your declaration says. So for really specific questions, talk to your association counsel. But the first thing is you can always amend your bylaws. If you're concerned and you want to make sure that you are compliant, it is not, it's not overly burdensome to amend the documents to add credit unions as one of the types of accounts that you can invest the reserve money or put the reserve money in. I tried to look at what WUCIOA said, or what was a qualified financial institution, in case your documents say something like, or other qualified financial institution, because that does define in the statute a credit union is one of those things. I think Ken pointed out you could certainly probably look at a community bank, since that is specifically one of the things listed, the savings and loan or whatever, savings bank. They probably have comparable interest rates to a credit union. That's just an aside. So you may want to look at that if you don't want to go through the bother of amending your bylaws. But I would imagine you'd probably fairly easily get member support to an amendment, because this is a benefit to the community. And, we've always talked about procedure and process, and this is certainly one of those things that some savvy owner, if you invest in a credit union and your bylaws say it's not one of the enumerated types of institutions, you can bet somebody's probably going to bring that up at some point. So definitely this is a good question to ask, and it probably is a reasonable amendment to make. And I think that I couldn't see any uprising amongst owners for this kind of change to the bylaws. Anything to add, Valerie?
Yeah, the only other thing I would add is some bylaws don't even require a vote of the owners to amend.
That's right.
So you might be able to amend it as a board decision without
That's right.
a vote of the owners, depending on what type of community you are. So I think, to get specific advice on this, as Lisa mentioned, you should check with your association attorney. And I think that's otherwise all we've got for that today. All right, our next question is this. I would love to know more about the proposed new law to speed up openness and transparency in board meetings moving through the legislative process. So I think we've kind of, I don't want to say beat this dead horse, but we've definitely talked about this a lot today already. But the one thing I haven't done is given you the bill number. So it's Senate Bill 5129. That is the current, or the bill that is currently before the legislature to modify WUCIOA as it now exists. It contains revisions to the meetings section of WUCIOA. And one of the things the bill does propose to do is make the meetings section applicable to everybody in 2026 instead of 2028. So you can monitor the bill online. I just gave you the link for where to find that. It's in the chat. And again, I'm going to beat another dead horse and remind you about the Monday Morning Minute that the LAC puts out. That's another way to monitor what is happening with this bill. If what you're asking about is specifics about the changes that are being made, I mean, one of the changes is something I mentioned earlier today, which is in the WUCIOA meeting section as it currently exists, there is a requirement to allow owners to comment on the business of the association at a board meeting. The new proposed revisions would require that owner comment period to be put at the beginning of the board meeting instead of at the end of the board meeting. And the reasoning behind that, which I think actually makes a lot of sense, is if you wait until the end of the board meeting, the board makes all of its decisions without taking into consideration any of the owner's comments on any of the issues the board might be voting on today. But if the owner comment period comes at the beginning of the board meeting, it gives the board an opportunity to consider the feedback of the ownership as it then goes through and votes on the issues before the board at that meeting today. There is, there is definitely like detail in the bill that allows the board to limit the time of the owner comment period. I think it allows for or requires 15 minutes at the beginning of the meeting for the owner comment period. You can limit owners to, I think, a minimum of 90 seconds piece. And I think that if there are too many owners trying to comment, that between the 90 seconds per person and the 15-minute cap, there's something in there about how, how you handle that. But I think the owner advocates rightfully pointed out a flaw in the general process, which is what we've seen most of our clients do, which is to put the owner forum at the end of the board meeting. What good does that do if the voting's already over? So that's just one of the changes that's being considered and is likely to be, to take effect once this bill makes it through the legislature this year. But the way to, to answer your question is how you track it through the legislative process. You sign up for the Monday Morning Minute emails and you check that link that I put in the chat once a week to see where it's at right now. I mean, like right now, I can tell you that it has passed the Senate. It's been introduced in the House and it's currently in committee. And let's see here. It is as of February 12th. Sorry, as of February 17th, it had its first reading in the House Civil Rights and Judiciary Committee. So another thing that you might benefit from when it comes to the Monday Morning Minute emails is that whenever we don't have a burning issue of a specific bill to update you on, we try to talk generally about the legislative process, because a lot of people don't know all the different steps that bills go through before they get voted on ultimately and enacted into law. And so we can explain in some of those Monday Morning Minute emails, like what are all the cutoff deadlines and what are all the steps that these bills go through before they are made into law. So anyways, I think that's the answer to the question.
Okay, next question is I think a short and sweet one. Many association documents set a 30-day timeline for ARC review and communications. However, both RCW 6438.180 and .062 allow for 60 days. Would this override the 30-day timeline that is traditionally standard for all other applications? And the short answer and the long answer is no. Governing documents can always be more demanding than the statute. So if the requirement in your bylaws is to approve an EV charger with 30 days, it still is compliant with the statute. And unless it specifically states that it overrides your declaration, the more restrictive time period or more restrictive language would control. So the fact that your governing documents have a shorter time frame is fine. If your governing documents had 90 days, then the statute would control and bring that down to 60 days. But because you're under that time frame, then your time period is still applicable to your community. I don't think that's it. Anything to add, Valerie?
Well, there's a follow-up chat in the question, which is that the same with meeting notices as well? And I will say, this is the language that you're looking for in the statute to determine if the statute trumps your documents. It'll say something like, notwithstanding anything to the contrary in the declaration or in the governing documents. Then the statute will say, you have to make ARC decisions within 30 days or whatever. So if you see language like that in the statute, then the statute trumps the documents. If the statute says something like, unless provided otherwise in the governing documents, this is the timeline, then you can go with what your governing documents say, because the statute specifically contemplates that. Notices, the statute is almost always going to trump, because it is very rare that we see a governing document with a more beneficial to the owners timeline for giving notice of meetings, for example. So a lot of times we'll see meeting notices in the governing documents where you can notice a meeting on 10 days notice to the ownership, but the statute requires 14 days notice. The statute trumps in that situation. So if that answers your question, I think we'll stop there, because I do want to try to make it through the rest of the questions that were submitted in advance. But if you want to ask for clarification in the comments, you can do that. And I'll move on to our next question, which is also a relatively short and sweet one. Have there been any changes to the reserve study guidelines in the past year? It seems they were looking into more standardization of inspection items and also the companies doing them. Some HOA boards decide what they want included in the study. So we are not aware of any proposed changes to the reserve study guidelines. There's nothing in front of the legislature as of now that we're aware of. But the statutes do set standards for things like what significant assets belong in the reserve studies. But it is also true that some reserve study professionals and some boards don't follow those standards, and some boards just don't even do a reserve study unless the membership, submits the petition that's allowed by the statute to essentially force that issue. So the statutes have pretty detailed requirements. The problem is that there's no significant enforcement mechanism other than if you do not have a reserve study that complies with the statute, you have to disclose that on your resale certificate, because it does pose a risk to buyers within the community and to the owners in the community if your reserve study is not compliant with the statute. There's a reason the statute requires what it does, and that is that it allows associations the information they need in order to financially plan to adequately maintain the building components, replace and maintain, without resulting in massive special assessments to the owners. So the short answer to the question is that there are no currently proposed changes to the reserve study guidelines. And I don't see any, I don't see any like new bills coming down the pipeline to do that. And certainly when those types of changes are proposed, we will make everybody aware here. Lisa, did you have anything to add to that?
No, I do recall we were talking about this is not really reserve study, but it's the reserve funds and then the changes potentially to allowing those to be invested in T-bills under the new statute, but nothing about the guidelines for the studies themselves. Yeah. Okay, next question. At what point does harassment become illegal harassment? What point is defamation legal defamation? What point is libel legal libel? Our board is being harassed. This is probably this is a very fact-specific question that you're asking, and you're definitely going to want to talk to your attorney, your counsel, about whether or not what is happening in your community is harassment, defamation, libel, etc., and whether or not something like a restraining order or something else is possible for your community. You can just look up those things online. You can say, what are the elements of harassment? What are the elements of libel? What are the elements of defamation? Just to get an idea of whether or not your cause of action may be actionable. And most of those torts have very specific things that the courts will look at to interpret whether or not your situation rises to a finding of libel or whatever that thing is. I know that we were talking before, Ken just sort of Googled libel, and there are very specifically 4 things, and you have to make sure that they all are applicable to you. And one of the most important ones you want to look at is whether or not you're actually harmed, whether or not there's a damage to you and whether or not damages can be made. But in any event, that's something you definitely want to talk to your attorneys about, whether or not there is something there. I mean, this kind of goes to that first question that we answered about someone just asking a lot of questions. I mean, it can, what is harassment to one person may just be a very annoying person to another. So that there definitely are, that's definitely a conversation to be had about whether or not, and we've certainly seen in other communities, situations where it is legitimately a situation where there is harassment or a behavior that needs to stop by an owner. I'm not sure if there's anything else I want to add there. Valerie, anything I missed there?
No, and I mean, I just Googled illegal harassment Washington State, and one of the first websites that came up defines unlawful harassment as a series of intentional acts by a perpetrator over a period of time that seriously alarms, annoys, harasses, or harms you without serving a legitimate or lawful purpose. These acts must reasonably cause you to suffer substantial emotional distress, or there must be like an act of violence, etc. So I think, this goes back to an example that Ken mentioned when we were, prepping for our Q&A today, which was that we had a case years ago where one board member was very clearly harassing another board member, and anti-harassment orders cannot be obtained on behalf of an entity. They can only be obtained for the protection of an individual person. But we did go before a judge on behalf of the harassed board member after the board as a whole voted to allow our law firm to do that on that owner's behalf. And the board agreed that it was harassment, but decided that it wasn't illegal harassment because it was related to the board's business. And so I think there's a difference between annoying behavior and sort of behavior that most people would consider to be harassment and what is legal harassment, which is the point that Lisa was trying to make. So this is a very long way of basically saying we can't answer your question. The only person that can answer your question is your association attorney. And if they're not equipped to answer it for you because anti-harassment law is a relatively specific practice area, they would absolutely be able to find you a good referral to someone who can help. Moving on to our next question. Could posting private property no trespassing signs on common area property be helpful to an HOA if we were to be sued by someone who is injured by using our property without our permission? We're mostly concerned with kids from a nearby neighborhood sledding, or do we need to put up a fence and block access in order to be free of liability? So I want to focus on that very last phrase, free of liability. And I just think there's no such thing as being completely free of liability, and there's no such thing as a guarantee. And if somebody tells you, if you do X, Y, and Z, then I guarantee you have no liability, then run away really fast and stop listening to that person, because there is just no such thing as a guarantee here, right? There are ways to reduce risk and liability. This is probably a better question for your insurance agent than it is for your attorney. But I think that if you're concerned about this specific situation in your specific community, then what I would tell you is ask your insurance agent and ask your association attorney, because your attorney can do things like look at the maps for your property, determine what hazards might exist, and give you a recommendation that's specific to your actual property, which we obviously can't do here. I think posted signs, generally speaking, can assist in mitigating liability or reducing liability for some situations if it is a very large, clearly posted sign. If there is something that's called an attractive nuisance, meaning the kind of thing that we all look at and be like, oh yeah, all the kids in the neighborhood are going to go do that, you know, sliding down I don't know, like a stairway pole or whatever. It's a good idea to post a no trespassing sign or do not use blah blah private property, whatever. If it is a very obvious risk, you don't have to post a sign because certain risks are considered legally obvious. And therefore don't require a warning in order to protect you from liability. But on the other hand, I don't think putting a sign up creates liability that wouldn't exist otherwise. If you just don't want people on your property, whether it's for liability reasons or not, you can absolutely put signs up. And then also you could, as a board, vote to empower a single board member to have people trespassed off the property when they are trespassing in violation of the posted signs. And what that looks like essentially is calling the police and having them remove the person from your property, being mindful of the fact that calling the police isn't always the best option for a lot of different reasons that we just don't have the time to get into here. So you can also just try asking, like if you've got kids that are sledding in your area and you don't want them there, have you tried asking them not to sled on your property? Because that's also something that you could do that might be effective, especially if they're showing up with parents. If you talk to the parents, they might see to it that their kids no longer come onto private property and do what they're doing. So Lisa, did you have anything you wanted to add to that one?
Nope, that's it.
Okay. You know, I think we have time for maybe one other question from the chat, and the rest of them we're going to have to save for next week. This question says, what are the appropriate motions, if any, for board voting on financials, treasurer's report, and auditor's report? You know, there is no specific or formal language that you have to use when making these motions. So if you're reviewing, for example, the monthly financials that your manager provides to you at your monthly board meeting, there might not even be a motion to be made, right? If the financials look accurate and all you're doing is looking at them and making note of them, then you might not even need to make a motion, or you could make a simple motion to accept the financial report as provided by the manager and then move on. And the same thing might be true of the treasurer's report. You can either note in the minutes that the board reviewed the treasurer's report and had no questions or concerns. That's one way to handle it. Or you could make a motion to approve the treasurer's report as it was presented to the board. I think with the audit, you might want to document the motion, especially if you think that there are any corrections that need to be made, or especially if the board thinks that any particular actions need to be taken as a result of the information that you view in the audit. But one of the things that we see is that people think you have to be really formal, or that you have to say things a certain way in order to be following the rules or procedurally correct. And that's really not true. Simple, clear, plain English is almost always better than anything complicated or formal that you might imagine to be better. And I think I just talked us right up to the 11 o'clock mark. So I think we are done for today. Thank you for joining us, and we will see you guys next week. Bye, everybody.
Bye.